Welcome. In this video, we'll explore South Africa's Companies Act 2008, a transformative piece of legislation that replaced the 1973 Act and reshaped the country's corporate landscape. We'll look at why a new act was needed, how it differs from previous laws, and what it means for businesses, stakeholders, and the broader economy. Whether you're a student, business owner, or just curious about company law, this journey will help you understand the Act's key features and its impact on South African business. South Africa has had three major Companies Acts, the first in 1926, the second in 1973, and the current Companies Act 71 of 2008, effective from 1 May 2011. Over the years, the 1973 Act was amended frequently to keep pace with business trends, but eventually a complete overhaul was needed. The 2008 Act was designed to modernize company law, align it with international standards, and reflect the country's new constitutional values. Some questioned the need for a new act, arguing that amendments to the 1973 Act were sufficient. However, significant political changes, a new constitution, and global business trends made a fresh approach necessary. The 2008 Act was crafted to ensure South African company law kept pace with international developments, promoted good governance, and recognized the interests of a broader range of stakeholders. South Africa's move to a new Companies Act was not unique. The UK introduced a new act in 2006, and Australia and New Zealand also updated their company laws to meet the demands of global competition. These reforms aimed to create simple, modern, and efficient frameworks for business, and South Africa's 2008 Act followed a similar path, learning from international best practices. 2008 Act requires courts to interpret company law in a way that respects constitutional values and advances the Act's spirit and purpose. Courts are encouraged to look beyond English precedents and consider global corporate law developments. This new approach ensures that company law remains relevant and responsive to South Africa's unique social and economic context. Section 7 of the Companies Act 2008 sets out its purpose: to encourage business activity and entrepreneurship by providing a flexible regulatory environment while ensuring accountability to stakeholders. The Act aims to balance growth and innovation with sufficient regulation, promoting economic and social benefits for all South Africans. One of the major innovations of the 2008 Act is the introduction of business rescue provisions. Instead of defaulting to liquidation, financially distressed companies can now enter business rescue proceedings, giving them a chance to recover. This process involves affected persons, including creditors, employees, and trade unions, who can initiate rescue efforts, reflecting the Act's inclusive approach. Alongside company law, the Closed Corporations Act of 1984 created a simpler, more affordable business entity for small enterprises. While new closed corporations can no longer be formed after 2011, existing ones continue under the Act. The 2008 Companies Act allows certain provisions like business rescue to apply to closed corporations, ensuring continuity and protection for small businesses. Drafting of the 2008 Act was preceded by extensive consultation. A 2004 government policy paper, agreements at NEDLAC, and input from trade unions all shaped the final law. The goal was to promote entrepreneurship, simplify company formation, and ensure the law was appropriate for South Africa's open, democratic economy. At NEDLAC, 5 key objectives for corporate law reform were agreed: simplification, flexibility, corporate efficiency, transparency, and predictability. These objectives guided the new act, ensuring that company law would be easier to navigate, more adaptable, and better aligned with international standards. Major shift in the 2008 Act is the move from the old capital maintenance rule to a focus on solvency and liquidity. Now, before dividends are paid or shares are bought back, directors must ensure the company's assets exceed its liabilities and that it can pay debts for the next 12 months. This modern approach protects creditors and ensures financial responsibility. 2008 Act adopts an enlightened shareholder value approach. Directors must act in the collective best interests of shareholders, but also consider employees, customers, and the community. The Act grants new rights to employees and trade unions, especially in business rescue situations, and provides remedies for minority shareholders. Directors are now held to higher standards of accountability and responsibility. The Act codifies fiduciary duties and the duty of care, diligence, and skill. Directors can be held personally liable for losses caused by contraventions of the Act, and courts can declare directors delinquent or place them on probation for misconduct. Sections 5 to 7 of the Act guide its interpretation. Courts must interpret the Act to give effect to its purposes, such as promoting entrepreneurship, transparency, and stakeholder balance. The law empowers courts to look beyond the form of transactions and arrangements to their substance, preventing circumvention of legal requirements. Founding document for any company under the 2008 Act is the Memorandum of Incorporation MOI. The MOI provides flexibility, allowing companies to tailor their governance, rights, and duties to their specific needs. However, certain core requirements, known as unalterable provisions, must always be met, ensuring consistency and legal compliance. Companies Act 2008 is organized into 9 chapters and 5 schedules. Chapters cover everything from interpretation and company formation to business rescue, remedies, regulatory agencies, and offenses. The schedules provide details on nonprofit companies, conversions, amendments, and transitional arrangements. Some fundamental features of the 2008 Act include the right of any person to form a company, minimal incorporation requirements, and a focus on flexibility. The Act differentiates between unalterable and alterable provisions, imposes greater regulation on companies with public impact, and introduces differential reporting standards based on company type. The Act recognizes several types of companies: public, state-owned, personal liability, and private companies. It also distinguishes between profit and nonprofit companies. Each type has its own requirements and governance structures, allowing for a diverse and adaptable corporate sector. While the Companies Act, 2008 is comprehensive, it does not codify all aspects of company law. The common law drawn from Roman Dutch and English law continues to play a vital role, especially in interpreting directors' duties and resolving issues not covered by the Act. Courts use common law principles to fill gaps and ensure justice. Several court cases illustrate how the new Act is applied. For example, courts have clarified the meaning of registered office and the rights of outsiders to access company records. These cases show how the Act's principles are interpreted in real-world situations, ensuring transparency, fairness, and stakeholder protection. In summary, the Companies Act, 2008 represents a modern, flexible, and inclusive framework for South African company law. It balances the needs of business growth with accountability, stakeholder rights, and global best practices. As South Africa's economy evolves, the Act provides a solid foundation for responsible, innovative, and sustainable business activity.